If you are a naturalized U.S. citizen, this is something you need to understand clearly. Because over the past few years, the U.S. government has quietly expanded how it reviews certain citizenship cases. Not to scare people, not to revoke citizenship broadly, but to re-examine how some people became citizens in the first place. This has shocked many Americans, people who took the oath years ago, people who voted, people who believed their status was permanent and untouchable. And for the vast majority of citizens, it still is. But there is a small and specific category that immigration authorities are paying closer attention to, and that is what has people concerned. Naturalized citizenship is one of the strongest legal statuses in the United States. It grants nearly all the same rights as being born here, but it is also different in one important way. It is based on an application, and applications can be reviewed. That does not mean citizenship is being taken away casually. It does not mean mass revocations are happening, but it does mean the government has renewed its focus on cases where citizenship may have been obtained improperly. This is known as denaturalization. It is rare, it is serious, and it is happening more often than it did in the past, not because laws suddenly changed overnight, but because enforcement priorities and technology have changed. Many people assume once you become a citizen, nothing from your past can ever be questioned again. That assumption is no longer fully accurate. In limited situations, past information is being re-examined. Not everyone, not randomly, but when certain red flags appear. This is why the phrase immigration crackdown is now being used in relation to naturalized citizens. It's not about everyday Americans losing citizenship. It's about the government revisiting how certain cases were approved, and that distinction matters. Because fear spreads faster than facts, and misunderstanding this issue causes unnecessary panic. This video is about clarity. Who is actually at risk? What situations raise attention? What has changed recently? And what naturalized citizens should realistically know? Because knowledge, not fear, is what protects people here. To understand why this issue exists at all, you have to understand how U.S. citizenship law works at its foundation. Naturalization is not automatic. It is granted based on eligibility, honesty, and legal compliance at the time of application. When someone applies for citizenship, they swear under penalty of law that everything they submit is true and complete. That oath matters, not just in the moment, but permanently. This is where many people misunderstand the system. They believe the oath only applies until approval. In reality, the oath applies forever. If citizenship was granted based on false information, omissions, or misrepresentations that would have affected eligibility, the government retains the legal authority to revisit that grant. This authority has existed for decades. What has changed is how often it is used and how cases are identified. For a long time, denaturalization cases were extremely rare, not because fraud didn't exist, but because identifying it was difficult. Records were paper-based, databases didn't communicate, information stayed siloed. That world no longer exists. Today, immigration agencies have access to historical records, criminal databases, international information sharing agreements, and digital fingerprints of past applications. Information that once sat quietly in separate systems is now searchable and comparable. This is why cases from 10, 20, even 30 years ago are suddenly being re-examined. Not because the government is hunting citizens, but because inconsistencies are now visible. Another important clarification is this: denaturalization is not based on mistakes. It is based on material misrepresentation, a typo, a misunderstanding, a forgotten address. Those are not grounds for losing citizenship. The law focuses on whether false information was material, meaning it would have changed the outcome of the application. This distinction is critical. Yet many people don't understand it. They panic over small errors that do not meet the legal threshold. Meanwhile, actual cases of concern often involve serious issues: criminal activity that was concealed, false identities, fake marriages, immigration fraud. In some cases, war crimes or human rights violations that were hidden during the immigration process. These are not common situations, but when they exist, they matter deeply to the government. Another misconception is that denaturalization happens quietly. It does not. These cases go through federal court. The government must present evidence. The individual has the right to defend themselves. Judges make the final decision. This is not an administrative shortcut, it is a legal process. And that process is long, expensive, and used selectively. So why does it feel like more people are hearing about it now? Because enforcement priorities have shifted. The government has invested in reviewing cases where fraud may have been missed in the past. Not all cases, targeted cases. And those cases often involve people who had prior immigration violations, criminal histories, or inconsistencies that were never resolved. This is where fear spreads incorrectly. People hear the word crackdown and assume all naturalized citizens are under threat. That is not true. The overwhelming majority of naturalized citizens are not at risk. They followed the law, they told the truth, they met eligibility requirements, their citizenship is secure. But the government is making it clear that citizenship obtained through fraud is not protected forever. That message alone is enough to unsettle people, especially those who fear they may have misunderstood a question years ago. Understanding the difference between fear and reality is essential because panic leads to bad decisions, and bad decisions create problems where none existed. To understand who actually draws attention under this renewed enforcement, it helps to look at patterns that appear again and again in real cases. The government does not randomly review citizenship files. Reviews usually begin when information from the past conflicts with information in the present. One common trigger involves criminal history that was not disclosed. This does not mean minor traffic violations. It does not mean misunderstandings about paperwork. It means arrests, charges, or convictions that occurred before naturalization and were either hidden, minimized, or falsely denied. Some people believe that if a case was dismissed or if probation was completed, it no longer matters. In criminal court, that may be true. In immigration law, it is not always the case. What matters is whether the information was required to be disclosed and whether it was disclosed honestly. If a question asked about arrests and the answer was no when the truthful answer was yes, that becomes a problem. Not because of the crime itself, but because of the false statement. Another major trigger involves immigration fraud before citizenship. This includes things like entering the country under a false identity, using fraudulent documents, claiming asylum based on false information, entering into a marriage solely for immigration benefits. Many of these cases were difficult to detect years ago. Now, records are compared across agencies and countries. If the system detects inconsistencies between early immigration filings and later applications, those cases may be flagged. Marriage-based cases are another area of focus. If citizenship was based on a green card obtained through marriage, and evidence later shows that marriage was not genuine, that can trigger review. This does not mean marriages that ended in divorce are suspect. Divorce is common and not evidence of fraud. What matters is intent at the time of application. If the marriage was entered into solely for immigration purposes and that fact can be proven, citizenship may be challenged. Another category involves asylum and refugee claims. Asylum is granted based on fear of persecution and specific factual claims. If later evidence shows that those claims were fabricated or materially false, citizenship derived from that asylum can be reviewed. This is especially true in cases involving serious misconduct that was hidden at the time of application. There are also cases involving identity issues. People who use different names, dates of birth, or nationalities at different stages of immigration can attract attention. In some situations, these inconsistencies were innocent. In others, they were deliberate. The government is now better equipped to distinguish between the two. Another important point is this: naturalized citizens are not reviewed simply because they travel, vote, or live normally. Normal civic life does not create risk. The focus is always on the original path to citizenship. Was eligibility genuine? Was the process honest? Was the law followed? When those answers are yes, citizenship stands. Another source of anxiety comes from rumors that immigration authorities are rechecking everyone. That is not happening. The government does not have the resources or the legal basis to relitigate millions of citizenship cases. Instead, enforcement is targeted. Cases arise when new information comes to light or when data analysis reveals inconsistencies that merit investigation. Sometimes this information comes from international partners. Sometimes it comes from criminal investigations. Sometimes it comes from later immigration filings for family members that reveal contradictions in older records. It is also important to understand that being contacted does not mean citizenship will be revoked. In many cases, people are asked to explain discrepancies. Some explanations resolve the issue entirely. Others reveal problems that lead to court proceedings. This is why professional guidance matters. Not because everyone needs a lawyer, but because reacting emotionally or impulsively can create unnecessary risk. Many people panic and think they must fix something immediately. They consider renouncing citizenship. They consider hiding travel. They consider making retroactive changes. These reactions often make things worse. The law does not punish people for being honest. It punishes fraud. Understanding that difference is the key to staying calm, and calm decision-making is what protects people. There is another critical misunderstanding that causes unnecessary fear, and it needs to be addressed clearly. Time alone does not erase fraud, but time does protect honesty. Many people assume that if enough years pass, nothing from the past can ever be questioned. That is only partially true. If citizenship was obtained honestly, time strengthens it. The longer a naturalized citizen lives, works, pays taxes, and participates civically, the stronger their position becomes. Courts take that into account. Judges do not lightly strip citizenship from people who have built lives, families, and careers based on lawful naturalization. However, if citizenship was obtained through intentional fraud, time does not make that fraud legal. That is why some denaturalization cases involve conduct that occurred decades earlier. This does not mean the government is reopening old wounds randomly. It means fraud does not expire, and that distinction is uncomfortable but important. Another area of confusion involves what does not trigger denaturalization. Let's be very clear. Naturalized citizens do not lose citizenship because they commit crimes after becoming citizens, get divorced, travel frequently, live abroad for periods of time, criticize the government, vote or participate politically, change religions or beliefs. Criminal behavior after naturalization is handled by the criminal justice system, not immigration law. Citizens are punished as citizens, not deported like non-citizens. This is a point many people misunderstand. Denaturalization focuses on the process, not post-citizenship conduct. Another myth is that dual citizenship increases risk. Holding another nationality does not make someone more likely to lose U.S. citizenship. Millions of Americans are dual citizens. That status alone is not a problem. The issue is always the same question. Was U.S. citizenship obtained legally and honestly? If yes, the inquiry ends there. Now let's talk about how denaturalization cases actually unfold, because this is where fear often exaggerates reality. Denaturalization is not handled by USCIS alone. These cases go to federal court. The government must file a civil lawsuit. Evidence must be presented. The individual has the right to legal defense. A judge decides the outcome. This process takes years. It is not secretive, it is not sudden, it is not administrative. There is no officer who can simply take away citizenship. The legal threshold is high, and the government must prove its case. This is why denaturalization remains rare. It is expensive, it is resource-intensive, and it is used only when the government believes there is clear evidence of fraud. Another important reality is that many cases end without denaturalization. Some are dismissed, some are resolved through explanation. Some fail because evidence is insufficient. The existence of enforcement authority does not mean it is always successful. Another factor that increases anxiety is media language. Words like crackdown make it sound like a sweeping action. In reality, this is targeted enforcement against a narrow set of cases. The government is not questioning the legitimacy of naturalization as an institution. It is reinforcing the idea that citizenship must be earned honestly. This message is unsettling but not unreasonable. Now let's address the question many people are silently asking: should I be worried? For most naturalized citizens, the answer is no. If you answered questions truthfully, disclosed required information, and met eligibility requirements, your citizenship is secure. If you are unsure about something in your past, panic is not the solution. Many people fear things that do not meet the legal standard for fraud. Misunderstandings are not fraud. Mistakes are not fraud. Language barriers are not fraud. Intent matters. Materiality matters. And proof matters. The people most affected by these cases are not surprised by them. They often know something was hidden or misrepresented. That is an uncomfortable truth, but it is an important one. For everyone else, the best protection is calm awareness. Do not speculate. Do not self-incriminate. Do not act out of fear. Citizenship is a powerful status, and the law still treats it as such. The current enforcement focus does not weaken citizenship. It reinforces its value. There is another situation that causes confusion and fear, and it involves contact from the government. Some naturalized citizens hear stories about people receiving letters, subpoenas, or requests for information, and they immediately assume the worst. It's important to understand what contact actually means. Not every letter is an accusation. Not every request signals denaturalization. And not every inquiry is about citizenship at all. Sometimes information is requested because of an unrelated investigation. Sometimes it involves a family member's application. Sometimes it relates to a past immigration filing that included multiple people. The presence of your name in a record does not automatically place your citizenship at risk. Another important reality is that denaturalization cases often begin quietly. They do not start with dramatic confrontations. They start with review. Files are examined, records are compared, information is cross-checked. Only after that process, and only if significant issues are found, does the government decide whether to proceed further. This means most reviews never become cases. They end quietly. This is why many people never hear about them. What raises anxiety is that people only hear about the rare cases that move forward. Those stories spread quickly and create the impression that something widespread is happening. It isn't. Another issue that deserves careful explanation is self-reporting. Some naturalized citizens worry that they should proactively contact immigration to correct past information or clear the record. This is dangerous territory. Voluntarily contacting the government without understanding the legal implications can create risk where none existed. There is a difference between correcting an error and opening an investigation. The law does not require citizens to revisit approved applications indefinitely. If an issue rises to the level of concern, the government will initiate contact. Taking unnecessary action out of fear often leads to unintended consequences. This is why measured, informed decision-making matters. Another area people worry about is whether family members are affected: spouses, children, parents. If a naturalized citizen faces review, it does not automatically affect family members. However, family immigration histories are often interconnected. If someone obtained citizenship through a chain of immigration benefits, issues at one stage may lead to questions about others. That does not mean everyone loses status. It means records are examined as a group. Again, this only happens when there is a reason. There is also concern about travel and re-entry. Some naturalized citizens fear that traveling abroad could trigger review or detention. This fear is largely unfounded. U.S. citizens have the right to enter the United States. Naturalized citizens are citizens. They cannot be denied entry, based solely on review concerns. If a case exists, it proceeds through the courts, not at the airport. Another misconception is that citizenship can be revoked administratively without a person knowing. That is not how the law works. Citizenship can only be taken away through judicial process. That process includes notice, the opportunity to respond, and the right to legal defense. No one loses citizenship in secret. No one wakes up one day and finds it gone. The system does not operate that way. The reason this issue feels alarming is because citizenship is deeply tied to identity. The idea that it could be questioned at all feels unsettling, but it's important to separate emotion from reality. The law has always included denaturalization authority. What has changed is visibility and enforcement capability. That visibility makes rare events feel common. They are not. Another thing to understand is that enforcement focus often follows public priorities. Cases involving national security, serious criminal conduct, or large-scale fraud receive attention. Everyday Americans who lived honest lives are not the target. That distinction matters. Fear causes people to imagine they are part of a group they are not. Most naturalized citizens are not on anyone's list. They are not being watched. They are not being evaluated. They are living their lives as Americans. And that remains the reality. As this discussion comes to a close, there is one final point that deserves careful attention. Much of the fear surrounding this topic comes from uncertainty, not reality. People hear fragments of information. They see alarming headlines. They listen to secondhand stories. And without context, those fragments turn into fear. But when you step back and look at how the system actually works, a clearer picture emerges. The United States is not questioning citizenship as a concept. It is not reversing naturalization broadly. It is not targeting people for who they are. What it is doing is reinforcing the idea that citizenship must be obtained lawfully. That principle has existed since the beginning. What's different now is the government's ability to detect serious fraud that once went unnoticed. That capability does not threaten honest citizens. It protects the integrity of the system. And that integrity matters because citizenship is not just a document, it is a legal bond, a social contract, a commitment between an individual and a country. The law takes that commitment seriously, and so should the people who benefit from it. For naturalized citizens who followed the rules, told the truth, and earned their status legitimately, there is no action required, no review to fear, no secret process unfolding behind the scenes. Your citizenship is secure. For those who worry about small mistakes, language misunderstandings, or minor inconsistencies from years ago, it's important to remember the law does not punish imperfection, it punishes deception. Intent matters, materiality matters, evidence matters. Fear often blurs those distinctions, and fear leads people to imagine danger where none exists. This is why informed calm is the most powerful response. There is no need to relive old applications obsessively, no need to assume the worst, no need to make drastic decisions out of anxiety. Citizenship, once lawfully granted, is one of the strongest protections under U.S. law. The government bears a heavy burden to undo it. That burden has not changed. What has changed is awareness. And awareness, when understood properly, is not a threat. It is reassurance, because it reminds us that the system is focused, not arbitrary, selective, not sweeping, and grounded in law, not fear. If there is one takeaway from all of this, it is this. Most naturalized U.S. citizens will never hear from immigration again about their citizenship. They will live their lives, raise families, work, vote, travel, and participate fully as Americans. The rare cases you hear about are not warnings to everyone. They are reminders that honesty matters, and that citizenship, like all powerful rights, is protected by law, not weakened by it. This concludes our discussion on the current enforcement focus and what it really means for naturalized U.S. citizens. Stay informed, stay calm, and stay confident in your status.